Hi, my name is Jim Hathaway, and it's my pleasure to tell you a little bit about the University of Michigan's program in Refugee and Asylum Law. We're really proud to offer the world's most comprehensive program in International Refugee and Asylum Law, a foundational course, 4 advanced seminars, summer fellowships that put our students into some of the most demanding and exciting places to learn about refugee law on the ground, and the capstone of our program, the Colloquium on Challenges in International Refugee Law that we offer every second year, so every group of students gets a chance to participate at one point in their law school career. And it gives Michigan law students the opportunity to work hand in hand with some of the world's leading experts on refugee law, judges, academics, lawyers, to reconceive the norms of the system in ways that courts around the world have frequently taken into account in adjudicating cases and governments have looked at in making policy. So this is a real unique opportunity for students at Michigan not only to learn refugee law from more angles than at any other law school in the world, but to actually go out into the world, experience refugee protection, and then come back through the colloquium process to help reshape those norms for the good of the system and for those of the people who really need the protection. Now, the colloquium, as I said, happens every other year, and we do a lot of research in-house on a topic that we think is cutting edge, where there's a real disagreement among courts around the world about how to handle it, and where we think there's a protection challenge that needs us to try to come up with norms to guide judges and governments in approaching that problem. So this year's topic is a great one. We're looking at the meaning of the notion of political opinion. A refugee is a person who stands the risk of being persecuted for one of 5 reasons, one of which is political opinion. And to help us find our way through the problem, we're really delighted this year to have with us one of the world's leading experts on asylum, Professor Dauvergne from the University of British Columbia Faculty of Law, who's agreed to do the authorship of the background study for us. So thank you so much, Catherine.
Thank you, Jim. Thank you for inviting me.
So Catherine is here today to actually take part with our students in a portion of this process. The students have completed their research. Catherine has drafted a first cut of her background study, and Michigan students have now spent the last 6 weeks, pulling apart every argument in Catherine's paper, thinking about it really hard, and trying to find ways to offer suggestions to improve the research that they'll present to Catherine this afternoon. Her paper will then be finalized and go out to the expert group in a couple of months' time. So Catherine, again, maybe you'd like to tell the group a little bit about why you were interested in this topic and why you thought it would make a difference if we could actually use the Michigan process to think it through.
Well, one of the things that's just terrific about the colloquium process and the idea of having Michigan guidelines is that in refugee law there is simply no official locus for international leadership. So there is no opportunity for an international court or an international oversight body to make clear pronouncements about key areas of the law. And one of the things that the colloquium does is that it tries to step into that really important void, a void which has grown larger and larger over the decades as refugee law has become more and more prevalent. There are something like 650,000 to 850,000 decisions every year around the world that use the basic elements of the refugee definition, and this colloquium is the only international source which is trying in a really careful and principled way to create standards for that decision making. Those standards are enormously important in any area of refugee law, not only because sometimes there are inconsistencies internationally between states, which leads to all sorts of problems, the idea that that people seeking protection would be better off in one state than another. So there are inconsistencies between states, but there are also inconsistencies in the asylum decision-making process within states, leading to problems that have become well known under the title of refugee roulette. If you go before one decision maker, you might get protection. If you go before another decision maker with the same, exactly the same factual situation, you might fail and be sent back at considerable personal risk. So the guideline process is very important in a general sense. But I want to talk a little bit about the particular topic for this year's colloquium, which is the question of what counts as a political opinion.
Because it might seem sort of an obvious one, right? I mean, everybody and his brother has heard of a political refugee. So what's hard about this topic? Why does it warrant study?
I might have said that 18 months ago before I started into the work. But I actually think that the fact that anybody might think that it's an intuitive idea is really the biggest part of the problem. Is that when we put the question of who should count as a political refugee in the hands of different decision makers all around the world, many of whom don't even have legal training, the idea that people can intuit what counts as political is a very problematic idea. And there are really diverse opinions about this coming from all around the world, both diverse opinions among the highest level courts in the world, and also really diverse opinions among first instance decision makers. There's very little agreement, and there's lots of contestation, and it's also an area where the number of people seeking protection on this ground has actually been growing in a couple of expanding areas in recent years, like protection for whistleblowers, if we think about Edward Snowden or Julian Assange. We can think of some high-profile individuals involved in exactly this kind of protection seeking. And also, if we think about, well, for example, the recent influx of child migrants from Latin America transiting through Mexico and coming into the United States, a lot of the situations on the ground which lead to those particular flows involve flight from unchecked criminal gangs. And there is a real tension in the jurisprudence in North America in particular about whether that kind of flight actually involves a political opinion, and also some question about whether children who are too young to formally engage in the political process might have a political opinion. So these are issues that have never been defined in law and are particularly pressing in the instant.
So you've talked about sort of the high-profile Assange-style cases and about kids fleeing gang-related activities. What are some of the other areas where political opinion seems to be tough for courts or governments to figure out?
Well, there's an almost unlimited number of areas. There are claims. I mean, one of the toughest things to figure out is whether or not somebody's being persecuted because of their political opinion when they are not actually engaged overtly in a political struggle. When they are, you know, going about their day-to-day lives, protecting, living their family, doing their work, and something happens that they react to in a way that you could say it's just instinctive, or she would have done that anyway, and they don't overtly connect to any major political cause, but they may nonetheless be at risk because somebody else thinks they're doing something political.
So a woman standing up to an abusive husband, is that a political act?
So in some states that is considered to be a political act, and in other states it's not.
And so what do you think causes some states to react one way to, for example, a woman who says, I'm not going to stay here anymore. I'm standing up for my right to be treated fairly. I'm not going to live with you anymore. If that attracts the husband's ire and he tries to hurt her for that reason, why would some states say, yes, she's at risk because of her political opinion, and other states say no?
Many decision makers approach questions about what counts as political and what doesn't count as political on the basis of the norms of politics in their own states. So one of the things that we're hoping to do by issuing guidelines is to create a way for people to shift their perspective away from thinking about, would we consider that political if it happened here, to instead try and think about, do we consider that political when it happens in another state where the political norms are foreign to us, where we're not as familiar with the human rights protections, or where there may not be a developed human rights system, and where cultural and traditional practices are completely different. So it's about guiding people in a decision-making process which requires looking at a cultural context that they don't have any experience with.
I think that's really critical. And just so everybody understands this, the issue that Catherine talks about is so important, because I think there's a common perception that if what you're facing is really bad at home, then you must be a refugee. But in truth, we actually limit it to people who can connect, as you said, the nexus question to who they are or what they believe. So if you're going to be hurt badly, but we can't link that to, for example, your political opinion, the law as it stands right now says you don't qualify as a refugee. So coming to understand, and I really like the cultural lens point that you've just offered us, coming to understand what counts as a political opinion in ways that may be different than the way we've grown up thinking about what a political opinion is in a Western culture is really critical, given that the overwhelming majority of refugees are coming from places that probably don't look like where we now live. Yeah. At the end of the day, you know, Catherine will lead the group through a discussion for 3 days in the winter of 2015. The 10 students and the 10 experts will debate all of the issues, and we hammer it out to a point of trying to reach consensus on 15 or 20 governing principles that we think unanimously ought to govern the way judges and governments handle this particular issue. We then issue these in multiple languages, we circulate them to judges and governments around the world, and we wait and hope to see what happens. And to date, the reactions have been interesting. There are some governments like New Zealand that has actually adopted into law quite a number of the Michigan guidelines. We had a recent case before the UK courts in which the argument was, do we adopt the UN's position or do we adopt the Michigan position? Yes, the UN won, but not without a good struggle. And I think really the goal here, as Catherine says, is to have a more informed, analytically sound approach to refugee law, so that not necessarily everybody gets in, but if for whatever reason a person is found not to be a refugee, it's done for reasons that we can honestly look ourselves in the mirror, understand to be principled, understand to be fair, rather than the product of reflexive or arbitrary decision making. And so we're incredibly lucky to have somebody who's been devoting so much time to thinking through the issue for us, Catherine. Thank you for that. And we're really excited about the discussion that's going to be happening in March.